I, as I said, I wasn't there. I had nothing to do with it. And through the whole paperwork in my trial, from probable cause hearing from 96 to all of that, all the evidence shows that I was not there, especially when the state's witness came to court and said and told the judge over and over, I never told y'all it was a Puerto Rican, short, stocky guy with long hair. It was a tall, black African American with short hair.
This crime is terrifying. It's terrifying. The victim's driving down the street. He tries to do something nice. He's ordered out of his vehicle. He's stripped. He's, and probably embarrassed and humiliated, his mother said. And then he's murdered after giving full compliance. And you're left saying, well, why did this happen? Why did this happen? And in order to answer that question, I had to go back to the PSI that was done after the jury returned its verdict. And there's a statement in there by the defendant where he says, and it's actually the writer of the PSI says, the defendant informs this writer that he is of the opinion that the deceased was working as a police informant and something went wrong, causing his death.
We are about to watch the Act 23 169 parole hearing for a man who committed this horrific crime back in 1995. Now, he does the one thing that you're not supposed to do at a parole hearing, and that is to claim innocence. Now, either he is guilty of this crime or the most unlucky man that we have seen in recent history. You see, he was busted wearing the victim's clothes, the pants, the shirt, underwear, and all. Now, he claims that he just bought the clothes off the street. He happens to be a victim of circumstances. Now, he was found guilty by a jury of his peers, sentenced to 80 years in prison. But because of a new act in Connecticut that says anyone under the age of 21, and you heard correctly, 21, not 18, is considered a child. So they should have the opportunity at parole. But again, he shows up at his parole hearing and says just that. I wasn't involved in the crime. I bought the clothes from a guy in the street. I thought it was nice clothes, even though it was two pairs, two sizes too big for him. So that's another question. But here he is claiming he's innocent. Now we will hear from the victim's mother and we will hear from the ADA and all unpack it with all the details of his appeal at the end. So with that, let's jump in.
Rasheen Giraud. My birthday is 12.
And your inmate number, please?
202206.
Thank you. This is a public hearing in accordance with Chapter 14, Freedom of Information Act, Connecticut General Statute 1-200, which applies to this procedure. If you have any questions concerning the above, please bring your questions to the attention of the panel at this time. Again, this is a public hearing. Mr. Giraud, do you have any questions?
No.
And are you willing to proceed with the hearing at this time?
Are you willing to proceed?
Yes.
All right, thank you. So as noted, this is a Public Act 23-169 hearing. It's being conducted in consideration of a parole application for Rasheen Giraud, inmate number 202206. Mr. Giraud is serving a sentence of 8 years flat with no probation to follow for murder, robbery first degree with a deadly weapon, larceny in the second degree, and kidnapping in the first degree. There is victim input in this case. There is also an offender accountability plan in place for the offender. It has been reviewed and shows that he has completed programming such as therapy, thresholds, voices, and the SRG program. He also reported to have completed Tier 2 and Beyond Fear, and he maintains a job assignment. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score on the RT falls within the moderate range for recidivism. Mr. Giraud, this is now your opportunity to express to the board why you believe you should be granted parole, and you may begin.
I have prepared a statement as well. Would you like me to speak before or after Mr. Giraud?
Attorney Conley, we're going to offer both you and Attorney Wolka opportunities to speak after he makes a statement and the board asks him questions, okay?
Okay, thank you.
You're welcome.
First, I would like to say thank you for giving me this opportunity for being here with I never thought I would have. And if it seems like I'm kind of stuck, it's just I'm really nervous. So, thanks for this opportunity to speak to you today. I have maintained my innocence since my arrest. That has not changed yet. What has changed over the last 30 years is me. Before this, I was in the community breaking the law. I smoked weed to get away from the reality of my past. I sold drugs to support myself. I joined the gang to feel part of something or family. What has changed me, I grew up and I matured. I realized that while I was focused on the injustice done to me and my family, the victim family is in a greater pain. I am sorry they have endured so much grief and pain. I can only relate that to the loss of my own family due to Mr. Gamble's death. I will never forget the connection I have to a man I never met. We are bound together by injustice. Where I went wrong was staying silent. At the time, I believed being quiet kept me safe. Instead, I've been punished for 30 years for a crime I did not commit. And my silence delayed justice that the Gamble family deserved. Over the last 30 years, I have never given up on myself. I am a kind man, helpful, and humble man. I will never put myself in this situation again. I will only surround myself with positive people. My deepest condolence to the Gamble family. But it's something that I wanted to tell the mother.
Okay.
And I have something, I don't know if Ms. D. Evans, that's Corey Tyrell, Gamble's mother, if she's looking, but I went over my modification and I remember some of the stuff she had said towards me from my trial and my modification. And that is one of the things that has changed into me. And her exact words was, Mr. Giraud, you are in prison by yourself because you didn't want to turn over the perpetrators. Mrs. Evans, that is true. At that time, I really was scared because of the people I was around. And that is one of the main things that I've learned, that if I would have really spoke up and said what I knew, I wouldn't have been here today. And I'm really sorry that you lost your son. Thank you.
Okay, are you done with your statement, sir?
Yes.
Okay, all right. Thank you for that statement. I want to begin by saying that the Board of Pardons and Paroles does not make findings of innocence. I want to make you aware of that, okay? That is not a function of this board. Our function here today is to determine whether you're suitable for release, okay? Any
Yes.
innocence claims would have to be handled through the courts. All right, so Mr. Giraud, we've reviewed your case thoroughly in preparation for this hearing today. So I want you to know we went through your case file, everything from the police reports to the transcripts, your entire institutional record, the memorandum submitted by your attorney, and the interview, the summary of the interview with our parole officer. So we're very well versed in your case. It was a lot of reading, so we're prepared. We do have some additional questions for you. When we're done with our questions, we'll ask the Office of Victim Services to provide input from the victim's family. Then the state's attorney and your attorney will have opportunities to speak as well. At the end of it all, we'll deliberate and we'll give you our decision here today. Okay?
Thank you.
We'll begin with my colleague, Mr. Rodriguez.
Thank you, Madam Chair. Now that's kind of been cleared up about we're not here to find any innocence or guilt at all. Share with us, because we're looking for suitability, right? We're looking for why we should consider releasing you. I appreciate your statement. I didn't hear a lot in it that really tells me that you should be released today. So what I'd like you to do is kind of think about those things that you've grown with and things that you've learned and things that you've gotten from where you're at to show us that, in fact, there should be a reason for us to even make that consideration.
Yes, I wrote some stuff down. Can I read it?
You may.
I made a roadmap about, the reason why I should be released. Excuse me, I'm nervous. One of the reasons why I think I should be released is because when I came in, I was young. I didn't know no better. I hanged out with the wrong people. And throughout the last 30 years, I realized that, and I learned through a lot of the programs that the people I was with was really not the people that was loving me. I came in, I didn't really know how to read, write. I took all of my programs without somebody telling me to do it at the time when I thought there was no light at the end of the tunnel.
Sorry.
And if I do be released, I have work waiting for me. I have a home, and a halfway house. I have all my contacts, and excuse me, I'm real nervous.
Well, let me ask, could you be a little bit more specific about, your contacts and
All right, yes,
what employment is it that you have?
I have a job waiting for me if I am released at the Oysters and Clam Farmhouse in Milford. And I will be working there from 6 in the morning to 3 in the afternoon. We would go on the boat, set the traps down and come back, and I'll go back to the halfway house. The owner's name is
We have that confirmed?
Joe is
Yeah.
his name. And the transportation, I have transportation. My new girlfriend, her name is Joe. She will be taking me from and back to the halfway house. And I have my plan for
So when I talked about contacts, I'm sorry, let me clarify it for myself and for you. When I talked about contacts, I meant more service-related contacts. What kinds of things are you going to have available for you on the outside, or have you prepared on the outside?
Yes, I have housing, which would be at the halfway house. I have my therapist that would help me like go to programs that I need coming out of 30-year sentence into society, different types of program. I have my reentry program for the New Haven halfway house. I have my the DSS people available for me to help me with stuff like getting my license, my insurance, so I could get my medication and stuff like that, because now I'm for the last 2 years I've been diabetic and stuff like that, and other type and
Okay, I appreciate that information. Thank you. What have you been doing in the facility what have you been doing since you've been there? I saw a lot of certificates that you sent in.
Yeah.
A lot of certificates. I saw some of the evaluations. Some were very good, some were not so good. But tell me about the program you've taken and how that's going to relate to you making the changes that you need to make.
Well, in the last 30 years, I took several programs, one which was Tier 2, which is like an NAAA program, which I would still like to go to that, even though I don't drink or do drugs no more. I got my certificate and license in traumatist, which that was something that I really like. I did it for 8 years, which is making glasses. I also have my certificate for creative writing, which is now I actually know how to write a book or something like that. My other certificate is
I saw your certificates. I want to know more what in those programs have changed you.
It changed me when I didn't, before I was shy. I didn't know how to speak to people. I wouldn't look at nobody in the eyes. So a lot of those programs, they actually show me how to speak to people and how to listen to people. Because at one time I didn't know how to. It showed me how to be kind to people and to appreciate people's life. It showed me how to interact with other humans and, you know, other people. It showed me that life is very important and family is a lot. And it basically it kept me out of trouble for a long time due to that. And you know, a lot.
Yeah.
I
want to go back to something you shared earlier on when you in your opening statement, you were talking to the family, to the mother, I think.
Yes.
You said that you didn't know him, but there's documents that say that you had connected with him around drug selling. So
No,
how do you work those 2 points out? How do you work out that you didn't know him or have anything to do with him, and yet there's some evidence of you having met with him?
I think there's some type of misunderstanding because there's not one evidence that shows me and Mr. Gamble together, and there's no evidence that showed excuse me, that showed that me and him ever interacted with each other. And that was aware and on transcript from my probable cause hearing.
Okay. I didn't remember reading that. I read something different, I think. But in any case, this is a really challenging case, right?
Yes.
For us. You've been convicted by a jury. You're, claiming your innocence. I'm not sure why you're doing, why have you decided to do these programs?
Because I wanted to change myself. Even though I say I wasn't involved with this crime, I did do a lot of bad things before I came to jail.
You have a past history.
Yes, I did do a bad. So doing this was my chance to change myself and make myself better. So at the beginning of my sentence, I did catch a lot of disciplinary tickets because I couldn't believe that I was sentenced to so much time for something that I didn't do. So at that time and at that age, I really didn't want to hear nothing from nobody. And so my family came to see me a few years after that. And they was like, listen, it's not over. It's not the end of the world. And that's when I changed my life and I started getting into program and getting into meditation and stuff like that.
Yeah, but even after your program, you still got some disciplinary reports. You had programs in 2017, but you still got some disciplinary reports in 2018.
2018.
So, and that wasn't that long ago. So I'm not sure exactly when you decided to make the change because it wasn't really that long ago.
But the incident in 2018 was a ticket, a SRG ticket. Somebody in the facility across the jail had got in a fight, which I was nowhere around. And I got on the phone and called somebody and told the person, tell them to talk to them. Now, the SRG people, before I even came to jail, before this incarceration, I was already known as a high-ranking member. And I tried to tell them that if I was really still involved in this and the gang activity, I wouldn't have to call somebody from the streets to tell somebody to do something. And I don't know if you read the transcripts of that phone call, but I wish you did, because you would see that there is no gang activity talk on that phone call, not just the ticket, but the transcripts from the phone.
I mean, it's not the only ticket in 2018. You got a refusal to give a specimen ticket too.
All right, and the refusal for that, for the last 23 years, I'm Taino Indian. The last Thursday of the month, I fast from Sunday all the way to Thursday before I get in a sweat lodge. I will eat nothing. So at that time, it was about, I think, 7 a.m. when the officer did his tour, and they smelled something, and within the next 3 cells. So they popped the door and they took all of us from the 3 cells that was there, and they took us down to urine. I was the only one that couldn't urine So I told him, I said, listen, just give me a cup of water because I haven't eaten for a day already because I'm fasting. And they was like, no, so you have 3 hours to give her urine. I didn't give her urine. I was taken to RHU. Then when Captain Claudia came, she asked me what was wrong. Why didn't I? And I explained it to her. And she said, so would you give her urine now? And I said, yes. Her and the officer went, got a urine cup, brung it. I gave up a urine. The urine was clean, and I never was taken out of RHU. And to say one more thing about the 2018 ticket, I was in SEG for, I think it was about 32 days. At that time, Connecticut didn't have the CT confinement movement thing. So there was no limit on how you could be in SEG, and this is how they would get people to cop out to the tickets. So the only way after 30-something days for me to get out of SEG was just to sign a ticket and I'll get out.
Yeah, we hear that a lot. Well, I'm still trying to struggle with, what real change is for you.
Real changes for me. Now I think before I do stuff, like before I would just do stuff and I didn't care about the consequences because of the time I had. But even before I found out that I had this hearing, I was already changed because now I help people. I push people around in wheelchairs voluntarily without even knowing that I had this hearing at all. I for almost 10 years, because I'm Puerto Rican, so a lot of the kids that would come into the school, they couldn't take their GEDs because they didn't know English. So for that time, for almost 10 years, I actually was the tutor for them to go bilingual and help them out.
Yeah, I read that. I read that you had to do that. You help students do that.
Yes, and I also was part of a program in Gardner, CI that the Quinnipiac High School, they used to come down and I used to sit down with the kids, and I think that's what I'm really good at is talking to like kids that's going down the road that I've been, but they didn't make it in here yet. And to me, I think that they would have more of an understanding speaking to somebody like me than speaking to a counselor that never been through their issue.
Well, I appreciate that's something you want to do. It's critical for young people to have example setters on the outside. I don't really have any additional questions at this point, Madam Chair.
Thank you. Thank you, Mr. Rodriguez. Okay, sir.
Reserve until afterwards.
Thank you.
So, sir, you've referred to your case as being corrupt. Do you want to tell us what you mean by that?
As being corrupt, as I said, I wasn't there. I had nothing to do with it. And through the whole paperwork in my trial, from probable cause hearing from 96 to all of that, all the evidence shows that I was not there, especially when the state's witness came to court and said and told the judge over and over, I never told y'all it was a Puerto Rican, short, stocky guy with long hair. It was a tall, black African-American with short hair. Now the judge got up and asked him at least 3 to 5 times, is that the guy right there? Look over there. And the state's witness said over and over, that's not him. That's not him. And then he was told to read his statements, and he told the judge, this is not the statements I even gave to the police. And then
Are you referring to Mr. Ward?
No, not Mr. Ward, Mr. Connolly.
Okay. Well,
Ward's testimony.
Yeah.
yeah.
There's a,
Ward,
just so I can help you out, Dennis Connolly is the witness he's referring to. It was in the probable cause transcript
Restaurant.
submitted, and I submitted that with the application.
He's a restaurant.
Yeah.
Yes, he was the one in the Papa's Pizza, but there's also issues with Ward's testimony, but he's specifically talking about Dennis Connolly.
so I guess the bottom line is, how did you come to be wearing the victim's clothes?
I sold drugs in the street. So, I knew the guy named Mike. And when I came out the building the next day, Mike and Ward was standing there with next to the car. I asked if they wanted to rent the car. I gave them 3 bundles of dope of heroin, and I rented the car. Now, when I got in the car later on to drive around, I noticed that it was a brand new coat and some brand new boots. So I gave Ward extra bundle of dope for the clothes.
What did you rent the car to do?
To drive around, because I go back and forth to pick. At that time, I used to go back and forth from New York to pick up drugs and come back.
And the victim's house keys being found in your belongings, how did that come to be?
The victim house keys was not found in my belonging. It was found in an apartment that belonged to Warucho. Warucho, what's his last name?
Well, the person who said you stored your belongings in a closet.
Yes,
in their apartment.
yes.
Uh-huh.
But the keys was not found in my belongings. The keys was found in a bedroom that belonged to the person that owned the apartment on his dresser. And due to the pants that Mrs. Evans said that was Corey Gamble's, Sean Thompson got on the stands and testified and said that those was his clothes.
And he lived in that. And he lived in that.
And he lived in that apartment also.
So this job opportunity that you're referring to in the clam and oyster farm,
The oyster farm.
is this a year-round position?
Yes, and if I did get the chance, I would work there until I got my license. And then when I got my license, my stepbrother, plus he's been driving trucks for the last 10 years, for the federal post office. They said that they would hire anybody coming out of prison as long as they don't have a child molestation case or a rape case. And you know, I would be working there, and I would like to work there for 5 years until I could get money to buy 4 vans to start my own company.
You're not talking about a job specifically being hired by the USPS, a subcontractor?
No,
Not the post office. The
not the post office, the
subcontractor.
subcontractor
Transport.
for the tramp. Yes.
How did you find out about this Milford job?
Oyster farm.
The oyster farm, yes. I had a celly, a young kid that he worked it there, and he mentioned it to me, and I was like, you know, I might have an opportunity of getting out. So he told me everything about the job, and I never had a problem of working. All my jobs that I have in here, I never got fired from them. So I was like, I wouldn't mind working there.
So your work history in the community, besides selling heroin, was in concrete?
Yes, that was when I was in Florida. I worked there for a concrete specialist. That was the only real job that I had, or legally job that I had. And that came to a stop due to an accident that I was in.
And that you want a New Haven halfway house to go to a job in Milford.
Yes,
Is that
because
it? So where
Yes,
did you meet this new girlfriend?
excuse me, what did you?
Girlfriend.
Where did you meet this new girlfriend?
Well, me and her, we went out a few times, like 2 years before I did come to jail, and we broke up, and she ended up leaving Hartford. So about 4 months ago, me and her, we share a mutual friend, and I used to always ask about her, and she said, you know, she's still living in Connecticut, she's still living in Hartford, and I asked for her number, and a mutual friend, she said, I'm not gonna give you the number, I'm gonna talk to her first, because she has a husband. So I said, if she has a husband, forget it then, because I don't want to mess stuff up. So I end up calling that mutual friend again a week later, and she was like, here go the phone number. She wanted to talk to you. I put the phone number on my list. We spoke, and the first thing she said was, put me on the visiting list. And I asked her about her husband, and she said they've been divorced for over 15 years. And ever since then, she comes up 3 times a week to visit me. And she's been one of she done more for me in the last 4 months than a lot of my own family did in the last 30 years. Sorry to say that though, but it's true.
So from the different jobs that you've held in the facility, I want you to describe your work ethic to me.
I'm a very good worker. I never had, I would do extra work. I never had, none of my supervisors look for me, or if they did look for me, it was to do somebody else's job. The longest job I did held was,
Please keep your comments focused on your work ethic.
all right, my work ethic.
Your work ethic. So how do you work? What do you do? How do you stay doing, hardworking?
Oh, I worked a lot with the glasses, which was most, so I'm a hard worker. I have no complaint about anything whatever my job was, I did. I never had no problem doing it. Making glasses was really my best job. I really liked it. And
So, Mr. Giraud, what I'm looking for is you learn to work well with your coworkers. You know
Yes.
to ask your supervisor for clarification on directions for a job, that you stay until the job is done. You're able to work as part of a team, that you can be counted on to show up on time and ready to work every day. Those are the kinds of things that make you an attractive employee for someone who's hiring.
yes.
And you need to be able to describe those strengths in a job interview.
But I always was there on time. I never missed a day of work. I would do somebody else's job. I'm really nervous right now, so excuse me. I did a lot of jobs for the state. I never missed a job date. I was always there. Whatever the job was, I've done it. And as far as even at one time, one of the supervisors, since I was so reliable at the work, he would sit back and have me be the supervisor of the actual class. And I would teach the class and they would get their certificates from me.
And if I could help Mr. Giraud out here, I think we also submitted his work reports, which I think they were he had very good remarks on each one.
Nope.
Not all.
No, and that's not the point. The point is to be able to represent yourself to a potential employer by talking about in generalities how you work in a job setting with coworkers, relate to supervisors, handle responsibilities, that kind of thing. So, but I think we've gone as far as we need to go with that. So, you, as you've pointed out, have served 30 years of this 80-year sentence, and you feel like you have been wrongly incarcerated. So how do you feel about that? Do you harbor some resentment towards people who did you wrong? Do you want to get back at people? How have you made peace with this, as you would put it, injustice in your life?
I don't want to get back at nobody, but I don't want to stop fighting my case. So because I really want to prove my innocence, and I really have no hate towards nobody. It just, when I came in, I was furious and mad at the system because I really didn't understand the system, and I didn't understand how I got stuck in the system for so long when I thought the system was like, it didn't go the way that I really thought it was. But as far as I'm at peace with myself now. I'm Taoist, and I study a lot of meditation. And for the last 20 something years, I've been into Native American, and I've been growing as a person, which helped me change. So the way I thought about 30 years ago, I don't think like that no more.
Good, good. All right, well, thank you for clarifying that, Mr. Giraud. Madam Chair, I don't have any more
Thank you.
questions.
Okay. Mr. Giraud, did you apply for a sentence modification?
Yes, I did.
Okay, what year was that?
I think about 2 years ago.
Okay, were you denied?
I was denied.
Okay.
Can I, do
The
you want
were the grounds for your sentence modification or your innocence?
the what?
Was the ground based on your innocence?
Did you file it based on innocence?
Yes.
Okay. Did you want to say something else?
Oh, yes, I wanted to ask you if you wanted to hear the reason why I was denied.
Sure.
Well,
Yeah.
the judge went over all of the paperwork and all over and the hearings and stuff, and he read all of the files, and he said you actually changed and you became a different person, and now you're a man and you educated and stuff. But the reason why I'm not gonna modify your sentence because you don't want to admit to your crime, and that was the reason the judge gave me.
Mm-hmm. Okay. So let me ask you a question. You started in your opening statement, you said you went wrong by staying silent. Explain
Yes.
that.
Because I didn't know who was involved in the murder until after I came to jail. And I think that when I did find out, if I would have said something, I wouldn't have been in jail right now. So that's why I mean that as from being quiet, because at that time I was involved in a gang. And there were situations where, like, if you was to speak to the police about something, you know, you could either lose your life or something like that. And at that time in Hartford, it was really bad.
At what time? The time when you came in?
Yes. And I had an alibi at that. And the reason why I didn't want to put the alibi in is because she had kids and there was drugs sold in her house. So I didn't want them to go and take her kids and stuff like that.
So you'd rather spend 80 years in prison?
I didn't think that I was going to get 80 years.
Well, did anybody tell you what you might get?
No.
You had to have an idea you were going to get a lot of time.
The lawyer that I had right at that time was Martin Zeldis, and we thought we was going to beat the case, and he said that if we didn't beat the case, we was going to get 30 years. So I told him,
Still a long
The
time.
prosecutor was offering
Yes, it
25
is.
years.
Yeah.
I think I'm 100.
So if you truly were not involved, didn't know anything about the case, why'd you lie to the police?
because I was scared
Scared of what?
of what could have happened to me.
I don't understand how lying to the police about what do you keep looking at? Can I ask you that? Do you have like notes on the table?
He
No, I
has,
have my notes right
he has
here.
his notes and I have my statement right
Oh,
here.
he's reading your notes. I think it's distracting to him to have your notes there.
Oh,
He keeps
sorry.
looking down at your notes. So it's just,
He has
okay.
his notes and I have mine right here. I'll move
Right.
it over.
Okay, got it. I guess I don't understand how lying about where you got your clothes would cause you harm.
I was in a gang at that time. And if I would have said where I got the stuff from, you know, I
You could
probably,
have easily said, I bought the clothes from some drug addict I didn't know on the street. Instead, you said you had purchased them and lied about different places. Like you had a bunch of elaborate lies. It doesn't make sense to me why you would go to those lengths.
because at that time I was also nervous and I was scared. If I would have said, I didn't know about the case until after I came to jail, what really happened.
Okay, so, all right, so we'll go back to that. Forget about what I was just asking. So you find out when you're in jail who commits the murder,
Yes,
according to you. So what you're saying is because you stayed silent, someone who committed this horrific
Horrendous.
murder is out on the streets doing God knows what for the last 30 years.
well, not for the last 30 years because that person ended up getting arrested and only doing 17 years for the same charges.
Okay, but you get my point. Because you
Yes, I
stayed
do.
silent, someone who committed this murder went free, never did time for this murder. I mean,
Yes.
how would you feel as the victim's family?
Yeah.
I would feel horrible. I would feel pain. I would feel
Mr. Gerard,
real.
Are you
Yes.
saying that the person who committed this crime went on to commit another murder and got 17
No.
years?
No.
Well,
Is the
what crime
person-
did he commit to get 17 years?
It was this charge or this crime right here for this case.
Sure. Like a school defendant.
Oh,
His name was Cleve Ward.
Oh, right. Yeah, I mean, wasn't he sentenced around the same time?
yeah.
Huh? Yeah,
Yes.
so he was always involved in the case.
He wasn't, when I got arrested, I don't think he got arrested until 2 years after I did. And that was when, one of the witnesses got in touch with the police, which his name was Norman Edwards. And he said that he was on a fire escape and he heard Mr. Cleve Ward speaking to Ruby saying that, do you think, Gerard would snitch on me? And then that's when, Norman Edwards got in touch with the police. And that's how Mr. Cleve Ward ended up getting arrested.
So why are you no longer afraid for your life, afraid of these gangs?
Because I've been out of the gangs and for the last 30 years, I matured and I seen what it really is. Like, if I would have knew now that a lot of stuff they pushed on you and make you think is really not true.
Okay, so they're not dangerous? You don't have anything to fear?
As of this day, no, I don't fear none of them no more because they took being with them. They took my life away and they took me away from my family. And at the end of the day, they did nothing for me.
What was your 2017 fight over?
I was the head scullery guy, cleaning the machines, and somebody that was there wanted to get involved in a gang, and part of his initiation was to take me out. So the guy tried to come and cut my throat, and I defended myself. And it should be two statements, one from two officers and one from the kitchen supervisor that also stated that they seen the incident go down, that I was at my job when a guy came in and tried to do harm to me, and I defended myself. I defended myself because since I was 9 years old, I've been into martial arts, so I know I know how to defend myself.
Okay. Speaking of the kitchen, in 2023, 2 years ago, you were fired from your job and you received a fair poor evaluation.
And what year?
23.
2023. I'm still working. And from
Maybe you got a
2020.
job back. You don't remember being fired?
No, I never got fired in 2023.
Did you guys see that?
I've been here in the same facility in the same block
Yeah.
since 2021.
Oh, I'm sorry. You were fired as the diet cook and put somewhere else.
No, that's not me.
What are you doing now? What are you doing now?
I'm a food server. And I never got fired from that job.
Were you a diet cook at one point?
No.
You've never been a diet cook?
No, the
What
diet
the
cooks
heck?
are in the kitchen. I don't work in the kitchen.
I'm not sure that I saw that either.
Did you guys see it?
Yes.
Okay, you pull it up. Thank you. All right, so you did the optical technician program and you made glasses for 8 years?
Yes.
What years were they?
From 2000 and when I came back from Virginia, which was 2001 all the way through like 2009, 2010.
Is that it? Okay.
That's just came to stone.
And what facility was that?
That was in McDougal CI.
Okay. All right. Well, that's a cool skill, huh? Learning how to make glasses. Yeah. I don't hear about that too often. When you met with the parole officer, you said that you wouldn't have any risk while you're in the community. And so I'm going to give you the opportunity because maybe you didn't understand the question. There's always going to be some risk, right? Do you understand what might make you fail, or what might be a trigger, or something that would put you back in prison?
I think I'm matured. I'm matured very well now, that I know I wouldn't put myself in those positions where something would even trigger me. And
Let me give you an example. A risk might be if you can't find work and all you knew how to do was sell drugs. A risk might be somebody from one of the gangs comes looking for you and you have to defend yourself. There's risks. Everybody has risks.
As far as finding a job, I would just keep looking until I find a job. And as far as a gang member trying to come look for me, I don't have to stand there and even go put myself in an argument with them. I know how to walk away now.
So you think it's going to be easy going back out after 30 years if you were to go out?
I don't think it's going to be easy, but as those two subjects, I think is easy for me. But as far as going into the community, I really don't think it's going to be easy, because 30 years is 30 years. But with the help of the therapists and the people that's out there that's going to help me, excuse me, I think I can make it.
Yeah. I just hope you're being realistic about everything. And I understand you had a tough time as a youth. You've certainly had some difficulties while you're incarcerated with your tickets. And I know 27 tickets might not seem like a lot to you, but it is to us, because, we saw somebody earlier who had 4 in the same amount of time. So, and I understand your explanation for why things weren't great when you came in. It took some time for you to turn it around. But I struggle, very similar to the judge that you mentioned in the sentence modification hearing, struggle with the fact that either you lied and let somebody else get away with it for some time, or, like I said, we're not here to decide innocence. The board doesn't do that. That's not our role, our function. So really what we're looking at is change through disciplinary reports, through programs. We're looking at rehabilitation. We're looking at a realistic release plan when you get out. And who's your therapist in the community? You mentioned you were going to go see your therapist. Who is it?
It's in your roadmap.
It's in my roadmap. I actually don't
How did
remember.
you create that roadmap, sir?
How did I create it?
Yes.
It would it's basically like a plan. Like if I was to be released, that roadmap, it'll be from that first day all the way to like at least the first.
Yeah, I'm not asking what the roadmap is. I'm asking how you created it. Where did you find all of those service providers and people that are on your list?
Or through my programs and a re-entry lady that's in a building here, and on our tablet.
Who is that re-entry counselor?
I don't know her name.
Okay.
And on our tablet now they put a whole re-entry thing where it gives you all of the information and shows you how to get in contact with everything, from as far as doctors and whatever you have to get in contact with when you are released.
Okay. All right. Well, yeah, I think it's smart to really start either reaching out to people or, getting a list together, names, just work on a really, really good plan. All right. I think I'm done with my questioning for now. Did you want to have something else?
Yeah.
Yeah.
Mr. Giraud, the job that you want to do at the clam and oyster farm, I would imagine that it's somewhat labor intensive.
It's
Do you know anything about it?
yes.
It's
It's
physical work, right?
yes.
Okay. And without violating any of your privacy, we have some details on your medical issues.
Yes.
And I'm concerned for you that that this might be more than you can physically handle, given your injuries and surgeries in the past. Do you have a plan B?
Yes.
What's your plan B?
I would be working and it's called it's called Les Cleaners. He goes around and cleans stuff for, like, I don't know if it's not Bradley's, but stuff like Walmart and Walgreens. He cleans the parking lots and does the floor, which in my file I have my certificates from custodial maintenance. I have all of my certificates and license for that. So I would be doing that if that was my plan B, doing floors and windows and stuff like that.
And
And that's from
that? Where's
that's
that
in New Britain.
business?
That's in New Britain.
Okay, thank you, Madam.
Thank you. And I'll retract my statement about the poor evaluation of the diet cook position. I was looking at the wrong person, so I apologize. You did not have a poor evaluation. Okay, so at this time, yes, we will ask the Office of Victim Services to provide input from the victim's family. Ms. Hamlet Williams, thank you for joining us.
Thank you, Madam Chair, for having me. Good afternoon, everyone. I do have the mother of the victim who I will be contacting via speakerphone, and I will also be reading a statement from the victim's sister. One moment, please.
Madam Chair, if I may, Shermy Swalcott for the state. I do apologize when you were asking for identifications. I was viewing the live link, but not in the room. The victim's mother, I believe, is in our conference room. So if I could be excused for a moment, I could see if she needs any assistance.
Thank you.
Or possibly even bring her here.
Thank
Okay.
you.
Yes, thank you.
Thank you, panel. You may begin with your statement.
Okay.
Hi, I am Beth, the mother of Corey T. Gamble.
My name is Shermy Swalcott for the state. I do apologize when you were.
Oh, she's got her sound going. She's got a, yeah. Can you just mute the computer that you're viewing on?
I'm sorry, can you please repeat? Can you lower the volume down? No, we're trying to do it right now.
To work. You just got nervous.
Hi, I am Deborah Myers, the mother of Corey T. Gamble.
Oh, she's got her sound going. She's got, yeah. Can you just mute the computer that you're viewing on?
One moment.
She would end up prosecuting my probable cause.
No, because she's newer than
Okay,
here.
the computer is muted.
Thank you. You may begin again.
As I was saying, I'm the mother of Corey T. Gamble. First and foremost, I just want to let everybody know we are human, and I do understand. I come here today to express my deepest feelings on this situation and my son's legacy. To keep coming to hearings and modifications for parole or probation is a slap in my face. Because my son was murdered senselessly for what? For you to kill him and joyride and put his clothes on and feel like you did something honorable? No. My son wasn't even in the streets. I mean, I would understand if he was a street person, hung out, did the things that you thought was good, but he wasn't like that. He was about school. He was the academic honor student. He was also a salutatorian at one school and valedictorian at another. He was about his schooling and his basketball. He was even scouted by the NBA. They came out to see him while he played for Hartford Public High School. Never had a chance to produce children, meet all his great nieces and nephews that he has now. And I can go on and on about the family on the Gamble side and my side. Corey was loved, he was appreciated, and he was a very humble young man. How can you even sit here and consider your freedom and you stole and robbed someone of their life, acting as you were God or somebody of some importance? Not only did you rob my son from his maternal belongings, but you robbed him of his life, which will never come back. I can only imagine what he was thinking, knowing I was kidnapped, carjacked, robbed, and made to strip his clothes in front of men and women that he didn't know, just for him to do as he was told and still get shot in the head and the neck, execution style. If you ask me, you got off lucky because you're still living. So on behalf of my son's legacy and my family, I deny you the right, the privilege to even think about getting paroled at this time. One sincere bone in his body of his freedom, because frankly, I wouldn't be seeing him on these streets. I cannot sleep knowing the person who murdered my son senselessly and carelessly, walking around like nothing. Sir, and I'll call you that because that's the type of woman I am. You got a long ways to go. You got a long ways to go. And you're still in denial about what you did and what part you played in this. You were stopped in the car with all my son's clothes on, except for his socks, down to the underwear. You didn't care. You never showed remorse. And all through the trial and your troubles, you did not care, not one bit. You going to these classes, taking courses, working as a chairman or whatever you do that makes you, that means nothing to me. I know lots of people incarcerated. Believe me when I tell you that. But what you did, you really got a lot to think about. And I'm sorry if your parents weren't there for you. Like my oldest son told you, your father came one day speaking to him. They were Muslims. He said, I can't believe this happened right after the Million Man March. Didn't it mean anything to you, blacks and browns, to get your lives together and try to care about each other, put down the guns, the knives, and the threats and the hostility, and live your life correctly? I work hard every day. I am still full-time employed. And believe you me, Corey's father, as well as I, were still employed, and we did what we could for our children. We weren't rich, we weren't wealthy, but we were common people. My father was a fireman for the city of Hartford. My mom worked for the state. And trust me, anything you want, you work for it. They would tell us, I don't want you hanging and being around that one. They called the shots in our lives. I don't want you with that one, and they would tell us why. And we did what we were told. That's right. You don't see me in a position like you. I don't go that way because I try to live right. I'm not 100%, I'm not perfect, but those that know me, I don't play with nobody's life. And when they came to my job to tell me, before they can open their mouth and ask for me, I said, I know why you're here. I felt it because my son does not go and stay out all night. And if they do, they're either on their father's side or aunts, many cousins in the Gamble family. I know where they're at all times. My son had finished college, 24, never got to put that degree to work, never got to use his degree. You and your certificates means nothing to me, his siblings, or anyone. And I'm glad you found something to do with yourself. As far as mentoring and helping those that can't speak English or afraid to do, I don't know what year that was, because our parents helped us. 1, 2, 3, all the way to 10 to 20, A, B, C, all the way to Z. We learned those things. We started in church and we went on and we moved on and we still go. But what you can do for yourself is sit and admit the heinous crime that you participated in. And believe me, you're not alone. You're not alone in what had happened. And as far as I'm concerned, your sentence is starting today. Your real sentence is starting today. It was originally 95 to life, then it was changed to 80. No probation, no parole. I didn't even know there was a law about that came out in 2015. One of my 17-year-old grandsons, high school student, told me when I got the letter from the BOPP that you were considering parole. And he said to me, Grammy Red, and that's REDD, as I'm called by all my grandchildren, age 38 all the way down to the great grand one. I got plenty of them. And they told me, yeah, there's this law. And I said, really? How did that get by me? But it did. And I'm reading up on it. I don't quite understand it, but you do know right from wrong. You do know right from wrong, whether you want to admit it or not. But that's what you got to do first. Admit your part in what you did. Admit your part in what you did.
Okay, Ms. Hamlet-Williams?
Yes. Are you all set, ma'am?
Yes, I'm going to stop here for now.
Thank you.
so much. Thank you. And now I'll read the following statement. To the honorable members of the Parole Board, I am writing to express my firm opposition to the potential parole of Rasheen Giraud, who is currently serving time for the violent assault, kidnapping, robbery, and murder committed on November 26, 1995, and against my beloved younger brother, Corey Terrell Gamble. The impact of this crime on my life and the lives of my loved ones has been profound and lasting. Since the day of the incident, I have lived with immense anxiety, devastating loss, and a void that continues to affect me emotionally, mentally, and physically. I often find myself reliving the trauma, especially around the Thanksgiving holiday, of which it was Corey's last, and his continued absence overshadows a family unable to come together without grief and anger resurfacing again. Even everyday activities can be overwhelming. The pain of what happened to my dear brother, who up until his murder led an exemplary life, full of love, kindness, and charity. That kindness and charity was offered to the murderer as an offer of food to someone who appeared to be hungry. Unbeknownst to Corey, his final act of kindness was a prey upon his belongings and his life. This is something I carry with me every single day. Additionally, Corey's murder impacted the hope of life as I was with child at the time. Corey was excited to be a new uncle of his first niece. Sadly, he would be robbed of meeting her and other nieces, nephews, and great nieces and nephews. Corey was a great uncle to my son, who wanted to imitate him and wear similar clothing to that of Corey's. My son was just shy of his 6th birthday at the time of the murder. A party was planned for him with Corey's help and enthusiasm, but sadly canceled due to the health scare of my unborn child. I do not believe that Rasheen Giraud has demonstrated enough remorse, rehabilitation, or accountability to warrant early release. Granting parole would not only undermine the severity of the crime, but would also place the community at risk. I share in the real concern, and along with my family, that this individual poses a danger to others, as well as the memory of my beloved brother, Corey Gamble. I respectfully urge you to deny parole and ensure that the full sentence is served, as the Honorable Judge Barry ruled in 1998 when he empathetically stated that, quote, he would come home in a body bag, end quote. Those words have come to bring some comfort that Corey's life did matter and held value. The impact of the senseless murder against Corey T. Gamble did not end with sentencing then, but it continues every day for those of us who were also harmed and must face his void in our lives. Thank you for considering my voice in this matter. Sincerely, sister to the case of Corey Gamble, victim. Thank you.
Thank you very much.
Thank you. So at this time, each of the attorneys will be afforded an opportunity to speak to a statement. We'll begin with the state's attorney, Wolcott. Attorney Wolcott, if you don't mind, before you make your statement, you can just, for the record, indicate your juris number and business address.
Yes. Make the get the juris number again. I always go through this each time. It's 428191. Business address 101 Lafayette Street, Hartford, Connecticut. And I'll double check the because it's an S juris number. Madam Chair and commission members, I've appeared here before you often to speak about the issue of public safety when we look at these cases. And I try not to compare any two cases. Each case stands on its own. The defendant stands on their own. The merit of the facts and the rehabilitative work stands on its own. But what's most striking about this one is that it really stands apart. Reading through the facts of this case was just nothing short of terrifying. I believe the victim's mother said it best. This was a horrific crime that her son absolutely did not deserve. Just looking at some of the facts and going back to even the ruling, the denial for the sentence modification. You know, this crime happened, it was about 2 a.m. and the defendant and a friend asked the victim for a ride and he gave it to them. And then he has them pull over in an abandoned, boarded up over in the Rice Heights housing complex. And he begins, at that point, it becomes a kidnapping. He orders him out of his vehicle. The victim complies. He orders him to strip naked. The victim complies. He orders him around the back of the car. Victim is out of the vehicle. His clothes are off. The defendant could have easily picked up the clothing, hopped in the vehicle, and drove off and went on his joyriding. But he didn't. He didn't stop there. After the victim had removed his clothes, and these are just the facts that were found by the jury and is in the appellate court decision, states after the victim had removed his clothes, the defendant ordered him to a grassy area and forced him to his knees. The defendant then fired 2 gunshots at the victim, killing him. The defendant gathered the victim's clothing and placed it in the backseat of the car. Then the defendant drove the car from Rice Heights to Edward Street, where he lived. Later that morning, Hartford police officers located the defendant in the vehicle wearing those clothes. They then got a search warrant for the defendant's apartment, and they recovered more of the victim's belongings. pair of pants, a black leather belt that went with the coat that the defendant had on, and a set of keys. This crime is terrifying. It's terrifying. The victim's driving down the street. He tries to do something nice. He's ordered out of his vehicle. He's stripped. He's, and probably embarrassed and humiliated, his mother said. And then he's murdered after giving full compliance. And you're left saying, well, why did this happen? Why did this happen? And in order to answer that question, I had to go back to the PSI that was done after the jury returned its verdict. And there's a statement in there by the defendant where he says, and it's actually the writer of the PSI says, the defendant informs this writer that he is of the opinion that the deceased was working as a police informant and something went wrong, causing his death. This was a hit. It was a hit and it was an execution. The defendant is terrifying and he's still terrifying. As I sit here and listen to him and I listen to his statement on my way just in transition, I heard his entire statement start to finish. Where he apologizes to the victim, but he wants to maintain his innocence. And as I listen to his statement, I listen to his words before the board, and I listen to how he answers questions, the words that keep passing through my head are, he's immature, he's delusional, and he lacks credibility in his presentation, complete lack of credibility. This defendant executed the victim. And instead of sitting here and saying that he apologizes and he's now a changed person, he sits here and denies gang affiliation that he entered DOC with back in 1998 and that he reaffirmed in 2018. DOC phone monitors are trained individuals. For this defendant to sit here and say, oh, well, I was just calling somebody, asking them to pass along a message of a fight in the street. These are trained law enforcement professionals listening in, saying this defendant is still Solitos. He's still a high up Solitos, and he's passing messages. They said he was discussing ranking structure, the Solitos at McDougal, and who's next in line for a position. He shouldn't be walking around the streets of Hartford or New Haven unmonitored. The 80 years he received, appropriate for the crime that he committed, and appropriate for the person that sits here before you today. Someone who has not matured, who is not credible in their presentation, who does not take responsibility, and is the same individual that back in 1998 executed a man who he thought was snitching. And we need to start to change this narrative. That mindset has no business in the streets of Hartford or Connecticut and would serve to undermine public safety. Thank you for the time.
Thank you, Attorney Wolcott. At this time, Attorney Conway, if you have any final remarks and statements you would like to make, you may do so now.
Yes, thank you. I have a statement prepared. And before I get into that, I'd like to just talk directly about this hearing today. Mr. Giraud worked very hard to prepare for this hearing today. And at one point you had asked if he was distracted. He has entire handwritten notes of a roadmap. And when he was trying to answer your questions, I was trying to point him to his roadmap. He has the answers. He is just incredibly nervous. And I also want to say that he has been my client for about a year now, and it takes more than 30 minutes to get to know Mr. Giraud. It takes more than 30 minutes to understand him, to hear him, for him to feel comfortable enough to really show who he is. So I understand some of these questions and answers did not present in the way that he wishes he would have, but it takes longer than 30 minutes to get to know him. And I've prepared this statement. I think it will help answer some of the questions of the underlying criminal proceeding. I know we're not here for an actual innocence determination. That's not what I'm saying, but there are issues and there are red flags that I think need to be considered when hearing Mr. Giraud speak. And I will proceed with that. So Mr. Giraud is someone who comes before the board today with deep gratitude and, to be honest, incredible nervousness. This opportunity was wholly unexpected. Before we review again the good things that he has done in 30 years. I think those can be gleaned from his packet. I want to focus the board to the essential aspect of Mr. Giraud's continued maintained innocence and the red flags in the criminal proceeding that point to that innocence. Equal justice for both Mr. Gamble and Mr. Giraud would mean a deserving and thorough examination and investigation into Mr. Gamble's death and Rasheen's innocence, which is not what the board is here for today, but which Mr. Giraud is pursuing through a habeas that is currently pending. In November 1995, Rasheen Giraud was mostly homeless, but stayed at an apartment complex on Edward Street in Hartford. Two men, Waducho and KC, also known as Shaw Thompson, were living together in a third-floor apartment on Edward Street, and Rasheen was staying between this third-floor apartment and an apartment on the second floor with his stepsister, Ruby Gonzalez, in that same building. Ruby lived there with her boyfriend, Cleve Ward. Both apartments had open-door policies, and everyone had access to each other's apartments, as they were all friends or in some ways connected Solitos members. On November 25th, 1995, Mr. Giraud went out with KC and Waducho to a bar until about 2 a.m. At closing time, Waducho and KC returned to the Edward Street apartment, as far as Mr. Giraud knows, where Cleve Ward also was. Rasheen Giraud did not return to Edward Street, but instead went to meet his then girlfriend, Raquel Rodriguez, where he stayed the night. Sometime in the morning hours the following day, the Hartford police responded to Rice Heights apartment complex, where they found Corey Gamble naked and deceased on the ground. Later that morning, on November 26, 1995, Rasheen returned to Edward Street, where he met Cleve Ward and Mike Fleming out on the front stoop. Mike and Cleve had a Pontiac Grand Am parked in front of the building that Rasheen knew did not belong to them. Cleve said that he had it available for a ride and they could hang out and use the car. So Rasheen arranged to use the car for a few days by giving Mike/Cleve drugs in exchange for the car. Rasheen used the car for the remainder of the day and the following. Inside the car were clothes and shoes on the back seat. Rasheen gave more drugs to Cleve as payment for the clothes. On November 27, 1995, Rasheen was pulled over by the Hartford police driving the Grand Am, which police knew to be stolen from Mr. Gamble. At this time, Rasheen did not give police a true answer about wearing the clothes, but he did say that he borrowed the car from Mike Fleming. The police report says they could not track that person down. Rasheen Giraud was ultimately arrested and charged for the murder of Corey Gamble, as he was found driving the car that Gamble rented and wearing a jacket and shoes that belonged to Gamble. 2 days after Gamble's body was discovered on November 28th, the police went to Papa's Pizza and interviewed Dennis Connolly, who provided a statement that he'd seen Corey Gamble with a tall, dark-skinned man inside Papa's Pizza around 2:30 a.m. on the 26th. They showed Connolly a darkened, shadowy Polaroid purported to be Rasheen and asked if this is the man that he saw. Notably, the police did not show Connolly a photo array. At no time did they show Connolly a picture of Cleve Ward. Allegedly, after showing the Polaroid, Connolly said yes and signed the Polaroid, but at the probable cause hearing in 1996, Connolly denied identifying Giraud and said that the photo they were showing him in court is not the same photo that they showed him at Papa's Pizza. Connolly also denied Giraud, the guy sitting at the defense table, as being the person he saw inside the pizza place the night of Mr. Gamble's murder. During the course of the investigation, the police obtained statements from Cleve Ward, Shawn Thompson, Waducho, Norman Edwards, Ruby Gonzalez, as well as others. Other items belonging to Gamble were found in the third-floor apartment where Giraud and Kennedy stayed and where Cleve Ward also had access. Ultimately, Rasheen elected to proceed to a criminal trial. On April 8th, 1996, at the probable cause hearing where Dennis Connolly testified, Mr. Connolly brought his own attorney as he was concerned about the prosecution charging him when he testified differently from the statement that he signed in 1995, which I included with our application. The state provided Mr. Connolly with immunity to testify at this hearing. He then testified adamantly that he never told the police that Corey Gamble was in Papa's Pizza with a Spanish man, but rather that he told police he saw Gamble with a tall, dark-skinned man with short hair. Rasheen is and was a short, heavy-set, light-skinned Puerto Rican with long braids. Cleve Ward is a tall, dark-skinned black man. Mr. Connolly insisted repeatedly that the police and the state's attorney became very upset with him when he met with them about a month prior to the hearing, where he finally reviewed the statement and told them that it was not correct. At the probable cause hearing, Mr. Connolly did not identify Rasheen as the person he saw with Gamble. Mr. Giraud's attorney tried multiple times in multiple ways at the probable cause hearing and the trial to exclude harmful testimony, exclude Connolly's original statement, and prove that a third party, not Rasheen, was the last person seen with Gamble at Papa's Pizza. However, Attorney Zeldis' efforts were thwarted by the judge's rulings. During the pendency of the criminal trial proceedings, Norman Edwards, Ruby's uncle, told police that he had heard a conversation between Cleve and Ruby in which Cleve expressed concern that Rasheen would snitch on him. Rasheen could have and probably should have indicated to police that it was Cleve that he obtained the car from and had out on the stoop with Mike. But causing harm to others was not in Rasheen's nature, and Cleve was at the time his friend and his sister's child's father. KC, the other person that lived with Raducho, where Rasheen stayed on the third floor, testified at the criminal trial that the cream-colored pants found in the third floor apartment were his. The state identified these as belonging to Mr. Gamble. Ruby Gonzalez, Cleve Ward's girlfriend, also received jewelry that belonged to Mr. Gamble from Cleve Ward. Ultimately, throughout the trial proceedings, Cleve Ward gave multiple statements and was the only person to put Rasheen with him at the scene of Gamble's death on November 26, 1995. In addition to statements, the investigation also revealed no GSR in the driver's seat of the car that Rasheen was found driving, and no GSR on Rasheen. But GSR was found on the passenger seat where Cleve Ward's own statement put him, as well as in the back seat of the vehicle. Importantly, Mr. Girard had an alibi for the 2 a.m. to later morning time frame, Raquel Rodriguez. This alibi was never investigated by police or by his attorney. Recently, I've spoken to Mr. Girard about this, and the reason that he gives for not involving Raquel as an alibi speaks to his good nature. Mr. Girard told me that in 1995, Raquel had young children, but also gang involvement, and did not always associate with the best people. He feared that if he singled her out to police at the time, then she could face the real possibility of losing her children to DCF, or at the very least having the threat of losing them because of her involvement. Given the childhood that Rasheen experienced, he would not involve a single mother to aid himself when doing so might be to the detriment of her children. Causing instability and turmoil in a child's life is not something that Rasheen was willing to do then or now. And I think these facts are where the factors of youthfulness need to be considered at this parole hearing. Mr. Girard did not have the requisite development at the young age of 20 to advocate for himself, to properly involve himself in his criminal proceeding. Not only that, he spoke himself about not being able to read or write very well. At the conclusion of the trial, Mr. Girard was sentenced to 85 years in prison for the death of Mr. Gamble. Over these last 30 years, he has maintained his innocence and attempted to prove it through improper legal vehicles. In 2005, Mr. Girard filed a petition for a new trial, which ultimately concluded in 2009, which was also included with the application packet. Mr. Girard also filed multiple motions to correct an illegal sentence. He filed for a commutation, which was denied at the pre-screen, and he also filed for a sentence mod in which he maintained his innocence but was dismayed by the outcome. In May of 2024, I was assigned to represent Mr. Girard in a Cassiano appointment to assess the validity of yet another motion to correct. In doing so, I obtained Rasheen's prior motion to correct transcripts, as well as his criminal trial transcripts, and met with Rasheen. In my review of these transcripts, the procedural history, I realized that he had never filed a habeas petition, and no attorney has had the opportunity to investigate and prove Rasheen's innocence. Following this, I explained to him what habeas is, what actual innocence is, and how there are red flags here that need to be investigated, how he deserves, as Mr. Gamble deserves, every opportunity to look into these loose strings and try to prove what actually occurred in 1995. That habeas is currently pending with Jason Goddard's office. And then we also had talked about the SRG affiliation ticket, and the state's attorney mentioned that again. Rasheen spoke about accepting this ticket in order to get out of SEG. We know that there are flaws in the way that DOC handles SEG and handles disciplinary tickets. Mr. Girard renounced his affiliation with Salitos. He was honest about his affiliation before he was incarcerated, and he took SRG, I want to say twice, I could be wrong, but he definitely took it following this 2018 ticket. He renounced his affiliation. He also removed all those callers from his call list and has had no contact. He has had no ticket since then and has had no issue with any affiliation from which I'm aware. In sum, I wholeheartedly believe that Rasheen should not be incarcerated any longer. He is soft-spoken, quiet, kind, considerate, and could better serve his community and ours by living free from the constraints of incarceration. I hope that we have adequately conveyed this to the board today, and thank you for this opportunity.
Thank you, Attorney Cross, Madam Chair.
Thank you. So at this point, the panel will enter into deliberation. You can listen to our discussion about your case, and we'll come back to you shortly with our decision. Mr. Rodriguez.
There's some case today. And there's a lot of losers in this case, a lot of who have lost. I don't know why Mr. Giraud didn't speak up earlier than this. I think it would have saved him a lot of grief at this point, and 80 years of a sentence. I mean, you know, programmatically, Mr. Giraud has taken some programs. He's moved to make some changes. I can hear that he's moved to make some changes in his life. He's figured out that those changes need to happen and need to take place. We're not here to decide his innocence. He's been convicted of this murder by jury trial. Those are the facts are that someone was assassinated and he was found responsible for that, or executed or whatever, and he was found guilty for that. And so that piece of it, you know, I don't know if there's anything we can do. That's what it is. I think he's making a move to make his life better and do better things. He says he has a roadmap to make his life better and to do things that he wants to get done. He seems to have outlined some things for himself. The nature of this offense, for me, is very, very difficult to look at. I'm having a very difficult time with that one piece of it. The fact that he had this many DRs, 36 total, 28 in this particular incarceration as recently as 2018, also challenges me in wanting to support discretionary parole for Mr. Giraud today. I don't know if there's anything that we can do in this particular situation. He's got an attorney who's going to be filing a petition on his behalf, and hopefully that will help. If he is innocent of this, I hope that it works for him and that it helps him out. I'm just not in a place right now with the nature of this offense. And
I think the habeas is pending, right?
Right, it's
Did I hear
pending.
that right? Yeah,
it's pending,
okay,
right?
all right.
That's what she said.
Okay,
The attorney also offered a lot of information around the case, but we're not here to adjudicate
right.
the case. So
Figure
that,
all that,
that wasn't something I really took into a lot of consideration. But his work that he's doing, I have taken into consideration, and I want to acknowledge that he has been making some changes. But I'm just not there today to approve a discussion parole today.
Thank you, Mr. Rodriguez. Ms. Turner?
So for the 20 programs that we're being told he completed, I would have expected Mr. Giraud not only to have demonstrated and been able to describe his change, but I would have expected him to have been better prepared to present himself to represent that change today. I'm stuck with the statement that he made that he didn't know what happened in the case until he was incarcerated. That, along with some of the explanations, ring quite hollow for me. And the injury and impact to the victim's family is tremendous and palpable. It was so well described by both the mother and the sister in terms of the loss and the pain of this process.
Mm-hmm.
So, I'm not inclined to take any action until the habeas moves through and the court has another look at this. I'm going to vote to deny due to the nature and circumstance, the injury and impact, and the inadequate evidence of offender change today.
I agree with everything that both of my colleagues have said. I think it really would be difficult for us to confidently say there's a reasonable probability that he would remain in the community without committing crime, or to say that he's been fully rehabilitated. I mean, he hasn't taken full responsibility, but he can't if he's claiming his innocence, right?
Well, and he even made the comment that he would never put himself in this situation again. But I don't even know what that means because he's claiming he didn't.
Wasn't in the situation.
Well, but we know he does admit that he was selling drugs and hanging out with the gang members and right. No, Yeah. It's a very difficult case and one that we don't see very often. Generally, it's pretty clear cut, someone takes full responsibility and expresses remorse, but we really have to consider that if what he's saying is true, then no one has ever paid for this murder. I mean, he spoke of a co-defendant who was convicted of a robbery. But yeah, it's very clear from the victim's family that they're still suffering after such horrible, horrible loss. Senseless is right, because it sounds like the victim had a real future.
And they continue to suffer as they described because
all of these hearings,
all of these
right?
efforts.
And all of it could have been avoided if
Correct, if you were just.
we just,
Is that what he did?
I don't know, told the truth or admitted to whatever involvement. I don't know. But
Sooner, as he said.
yeah. Yeah, I mean, the case was still ongoing.
Yeah.
Yeah,
I mean, he's still losing his life, but he's lost most of his life having to be in prison.
right, right. So I agree. I would deny it today, but given the nature of this public act, I would bring the case back to rehear it and see if there is any other changes or. Yeah, I mean, we have to give a date today. We can't just leave it open-ended, but maybe 5 years.
All right.
What are your thoughts?
I could go with that. I could go with that.
Ms. Turner?
I would assume that at that point, taking into consideration feedback today and whatever happens with the habeas, but that is a real gesture.
It is.
I'm concerned about tying the next panel's hands, but perhaps something mitigating will happen between now
Between now
and
and
then.
then.
Yeah, I don't think we'd be tying anyone's hands. I mean, especially if everything stays the same. I mean,
Well, and I sure don't know what to recommend.
yeah. Well, all right.
5 years.
Yeah. Reading now 25. 30. All right, in the matter of Rasheen Giraud, inmate number 202206. I'll move to deny parole at this time. We'll rehear the case in June of 2030. Denial for the following reasons: the nature and circumstance of the current offenses, the injury and impact to the victim and the victim's family, and inadequate evidence of offender change. Anything further? Is there a second to the motion? All in favor? Aye. The only thing we can recommend is that you continue to work on yourself and come back. I understand you're nervous, but come back with a good release plan and greater efforts at rehabilitation, work, education, whatever you can do. And certainly we look forward to hearing what happens with your habeas case. But we wish you the best, sir, and we thank everyone for their participation.
Thank you all. This is the Public Act 23169 hearing for Rasheen Giraud, inmate number 202206, and it is 1:34 p.m.
We're going to take a 5-minute recess. We'll come back at 1:40. Thank you.
Attorney Conway, we do have a case in that room after you, so if you and Mr. Giraud could exit the room.
That's what I was just gonna ask.
Thank you.
And they denied, and it's cases like this that always make me feel warm and fuzzy again about the Connecticut Parole Board. But don't worry, I'm not delusional. They quickly do something right after that makes me upset. But this is like the love-hate relationship. I thought they handled this case wonderfully. I thought they handled it quite well, asking the right questions, letting the victim speak without any interruption. This is something that they always have done a pretty good job at, and really just calling this guy out for what it is. It really is nuts. And look, we'll go over the appeal. Not that it's really necessary, because the ADA did a fantastic job. The defense attorney referenced it by reading the entire part. So I'll just go first. I'll let just talk off. Let me get some thoughts off my chest. It's interesting. When I first listened to this here, I listened to this hearing while stretching and doing like a walk without having any context. So I had no context. I didn't read the appeal. I just came in and listened. And, there was no intro like I had prepared for you. So I just go off with him saying how he's innocent. And he's really insistent on being innocent. And I have to admit, I was believing him. For one thing, it's like, to go into a case claiming you're innocent when it's just not the smart thing to do is never a good thing. So, sometimes you get some points for that. And then I'm just thinking, okay, maybe he's just the most unlucky man in the world. I mean, this could be a Hollywood movie. He's for some reason, he buys the pants, the underwear, the shirt from somebody, even though it's 2 sizes too big. I mean, the guy's a basketball player. He's obviously not a basketball player. And he puts it on, and then the cops come, and I don't know, he's driving the murdered guy's car. He's wearing his underwear. They go into his apartment and they find his stuff. But it's just all this horrible coincidence. And it's like, you know what? No, I can't. If you want to make this a Hollywood movie, then go ahead. But I just don't buy it. I don't buy it. It's like, you are so guilty. And his only defense is like, and we can go over that in the appeal, is that the witness said it wasn't him, it was someone else. And then he's such a chivalristic man because he was willing to serve 30 years instead of getting his girlfriend at the time in trouble, or the CPS to take the kids. So it's like, it's just, come on, man. Come on. You think we're all stupid? But I have to admit, I was believing him at the beginning until the ADA comes and speaks, and she just lays it out beautifully. I love the job that she did. And Mom spoke, and what a great job, Mom, dropping a mic on him as well. And it's like he sits there and just says, and then, there's another thing about how unprepared he is. And his attorney, who's known him for a year, who comes up and says, you can't know a man by just 30 minutes with him. And I said, well, first of all, it's been like an hour and 15 minutes. So, but, besides that point, it's like, we're not just judging him by the 30-minute interview. We're judging him by his record in prison. We're judging him by even the plan that he has. He comes to the parole board after being a high-ranking member at a gang, insists that phone call, which I'm so glad the ADA dropped the mic on him. It's like, no, I wasn't doing anything related with the gang. I was like, so you're calling us stupid again. And then your plan is to go, because your young Sally told you about this oyster, farm where you're going to go out on a boat and drop things. You're all of a sudden going to magically, poof, get that job. And I don't know much about, but if it has anything to do with lobstering, which the only thing I know is like watching YouTube channels, it's not an easy job. And if you don't have sea feet, if you have no history of going on a boat, the odds of you being successful at that are probably really small. It's not an easy job to just get on a boat and spend all day dropping those things and then picking them back up. I have a hard time. I have a really hard time believing that this man was going to hire this guy at his age, 50 years old, never been on a boat in his life, to all of a sudden spend 12 hours a day on a boat dropping and picking up clam traps. I just don't buy that. It's one of the worst plans. And then he has this girlfriend that he's known for 4 months. 4 months. Who's going to drive him to and from every day to go to work. That's his plan. And she's done more for him in 4 months than his family's done in 30 years, which is not something you probably want to admit at your parole hearing. And then his next plan is to go do the contracting job for the USPS driving a truck. I guess if that doesn't work, this is his other option with his brother-in-law, which I don't understand how you're saying brother-in-law when, like, I'm confused about that. Is that a misspeak? But and then he's going to go and buy 4 trucks of his own. He's going to go, which is magic poof again. He has money to buy 4 trucks, and he's going to be a successful entrepreneur. And so what's he learned in prison? Well, he's learned how to make eye contact, something I didn't see him do with his attorney, which was kind of like, you could see he still couldn't make the eye contact. So clearly he didn't learn that. And he was pushing wheelchairs. That was something else that he accomplished. Now, why was he still insisting that he's innocent, knowing that it would backfire? I think that he probably got stuck in a catch-22. My guess is that he filed the habeas corpus before he knew that he was eligible for Act 23-169. Act 23-169 only came into play about 2 years ago. So he's probably in the motion of it, and now he's screwed. He's, oh my gosh, I can qualify because I was under the age of 21 for a parole hearing, but I have this pending case saying I'm innocent. I've been telling everybody I'm innocent. So now I'm stuck. This is like the perfect analogy of why when you're caught in a lie and it's like you got to keep digging further and further and further. And I think that's probably what happened, is that he qualifies for this Act 23-169 hearing, but he has his habeas corpus and he has a choice. He can show up and say, I was lying, I'm actually guilty, or he can go, which won't work for him. I mean, that's not going to work because the parole board's going to call him out on it. So he has to instead say, I'm actually innocent. I'm still innocent. And, and that's why he's doing it, because he had no choice, right? Not because he's actually innocent. That's my opinion. Now they're going to go and have to wait till the habeas corpus runs through, and there's no chance that he's going to win this habeas corpus. It's like it's just weak. Now we can go over Dennis Connolly. This is who he was talking about as to why that witness that he was. But let's just start from the beginning. The jury reasonably could have found the following facts. At about 2 a.m. on November 26, 1995, the defendant, Rasheen Giraud, observed the victim, Corey Gamble, pull up in a car to use the telephone at a telephone booth, remember those, at a Hartford gas station. The defendant approached the victim asking for a ride to Charlie Oak Tree Terrace. Now, this entire thing is totally weird, because it's like, who gives a stranger a ride at 2 a.m. at a gas, And subsequently, the defendant called his companion, Cleve Ward, over the telephone booth and told Ward that they had a ride. The defendant and Ward enter the car. The defendant in the front passenger seat and Ward in the back seat on the passenger side. Again, this brings the question: was there something more? Like, was he really just a naive kid that said, "Sure, I'll give you a ride"? I don't know. I mean, I guess we have to assume that. I know that it was brought up in the case in this parole hearing. Was there something more? Were you dealing with each other? Was he an informant? I don't know. The defendant then directed the victim to the boarded up Rice Heights housing complex. There, the defendant pulled out a gun and put it to the victim's head and ordered him out of the car. The defendant took the victim to the back of the car and ordered him to remove his clothes. After the victim had removed his clothes, the defendant ordered him to a grassy area and forced him to his knees. The defendant then fired 2 gunshots at the victim, killing him. And the defense attorney used the word assassination versus execution, which makes me again wonder, was he I don't know. The defendant gathered the victim's clothing and placed it in the backseat of the car. Then the defendant drove the car from Rice Heights to where she lived. And sometimes I miss things when I listen to these hearings. So if you caught it and I missed it, put it in the comment section. Later in the morning, November 26, 1995, Hartford police officers were directed to the parking lot at the rear of the building, where they discovered the body of the victim, who was wearing only socks. Thereafter, the police interviewed the victim's mother, that same mother who showed up today all these years later, who told the police that in the early morning hours of November 26, she asked her son to move the car that she had rented, the 1995 Pontiac Grand Am, from the apartment building. She told police that this was the last time she'd seen the victim. And if you can imagine that guilt she probably lived with, not that she should live with the guilt, but that's just guilt that you would have when you say, hey, can you move my car? And then that's what happens, right? The police then began searching the car that the victim's mother had rented. At approximately 9:58 p.m. on November 27, 1995, Hartford police observed the car at the gas station in Hartford. Good on the cops for looking for the car. How many times have we heard, especially back in the day, where they would say, we're not looking for somebody until they're missing for like at least 48 hours, right? The police pulled the car over a short time later. The defendant was driving the car and was wearing boots and a leather coat that had belonged to the victim. In the pocket of the coat of the victim's electronic organizer, remember those? And what a moron. You kill someone, drive his car, wear his clothes, The police then obtained a search warrant for the defendant's apartment, where they recovered more of the victim's belongings, a pair of pants, black leather belt that went to the coat, and a set of keys. I mean, it's like, come on, bro. Like, this is not a Hollywood movie. You are not some, what's his name? Says this. I've been watching his YouTube, Justice Warrior True Crime, who says, you're not a Bubba Angel Aladdin. Is that what he says? You're just not, right? The defendant was charged with murder, felony murder, robbery in the first degree, larceny in the second degree, robbery involving an occupied motor vehicle, and kidnapping in the first degree. After a jury trial in June 1998, the defendant was found guilty on all counts. The trial court, True Justice Crime Justice Warrior, I watch him a lot. I don't know. I can't remember his name. Vacated verdict with respect to the charge of the robbery involved the occupied motor vehicle and rendered judgment of guilty in the remaining charges. Okay. Now part of his appeal. So his appeal is that a trial the defendant called Dennis Connolly. So here's what he was talking about, how his defendant was. So, and this is what his, I guess, the crux of his habeas corpus is. But let's see. As a defense witness, before Connolly was sworn, the defendant moved that the state be compelled to grant Connolly immunity. So he wants his witness, maybe his only witness, to be granted immunity relative to the testimony of Mr. Connolly, with the exception of any perjury. The request did not distinguish between perjury committed before Connolly was granted immunity and perjury committed by him when testifying after such grant of immunity. Immunity, of course, may not be a license to lie while giving immunized testimony, blah, blah, blah. In order to consider this claim, we examined the record of the trial court. The defendant told the court that Connolly had testified at the probable cause hearing as a state witness. Okay, so he testified as a state witness in the probable cause hearing and had been given immunity by the state. The defendant contended that because nothing had changed, the state should have required to grant Connolly the same immunity as a witness for the defense as it granted him as a witness for the state. Okay, that sounds fair, right? If you're, why not? It should be the same rules. Defense counsel stated that he did not have any case law to present, was not sure if any case law exists, but because of circumstances, the same immunity should be granted at trial. So maybe this is what the habeas corpus is about, which is his defense attorney should have brought case law and didn't. Let's see. The state responded that Connolly had been given immunity at the probable cause hearing for making a false statement, a Class A misdemeanor, as to which the statute limitations had at the time of trial now expired. Defense counsel did not dispute this claim. The court thereupon denied the defendant's request. So the state responded that Connolly had been given immunity at the probable cause for making a false statement, a Class A misdemeanor. So they're saying, so because I guess they're just saying that because that immunity had now expired, that they're not required to give him immunity, I think, or that because it was for a Class A misdemeanor, it'd be I don't know, but in short, they didn't grant him immunity, and the defense counsel didn't dispute it. So this is again probably what his habeas corpus is about. So the defendant now argues in court that he should empower trial courts to compel the state to grant immunity to defense witness in certain circumstances. The defense acknowledges that no such rule exists in Connecticut. The defendant acknowledged this. Okay. We recently recognized that some courts, such as Second Circuit and Burns, have held that under certain circumstances, the federal constitution might require immunization of defense witness. We previously declined, however, to decide the merits of the theory of those cases in absence of circumstances that would be given to rise to their application. We do so again in this present case. So because of this, the defendant did not bring Burns to the attention of the trial court, nor did he set forth the trial court any circumstances required to invoke Burns. Under granted the court, the government, he has changed discriminated, blah, blah, blah. Been in the last 8 years. We have yet to be presented with a case in which the defendant gets Okay, so the requirement burdens presents a very difficult burden for a defendant to meet. Although our test requires the government to grant use immunity has been in place for at least 8 years. We have been presented with such a case. The defendant gets over the first hurdle, let alone succeeds entirely. The defendant, I'll leave the link in the description if you want to go over this on your own. I kind of, I think they're just talking about whether or not they had a right for him to be granted immunity, and that because they didn't, he wasn't able to give a proper defense, and that his attorney probably should have brought up similar cases as examples or should have done a better job fighting for the case. Remember, I'm not an attorney. I just learn as I go. I'll leave a link in the description. Let's see if there's something more here. December 8th, 1995, sworn statement. The police are concerned that crime and making a false statement. Police, both the trial judge and the state made it clear that probable cause hearing immunity offered Connolly. It could not apply if Connolly perjured himself. The state's attorney stated that the probable cause. I mean, it's just, there's nothing here. Like, what was this witness going to say anyways? And the whole thing is so silly. Again, you think about that he was saying, well, I knew who did it, but I didn't say who did it. Now, you could say one excuse, he was afraid that he'd be killed. But it's like, if you're facing life in prison or getting killed, you probably are going to rat, right? And then you can go under, you do whatever you need to do. And then he also said that his girlfriend at the time knew, but he didn't want to get her in trouble. He was so chivalristic. He was a knight in shining armor, and he was gonna go. And they call him out on it. They're like, well, you were gonna go and spend life in prison? And he said, well, I didn't, I wasn't found guilty yet. And so what was your plea deal? 30 years. So you were gonna spend 30 years in prison? It's just BS. I don't buy it. I don't buy it at all. And these are the cases that you can't get out of this. You're not going to win this on appeal. You're not going to win a new trial. You cannot be found. It's like if you're found with the victim's clothes on, driving the victim's car, and with the victim stuff in your apartment, you know what? Like, even if you're innocent, you're just guilty. I mean, it's like you can't get out of this. 40 years later, they're not gonna, you're done. You gotta bite that bullet and approach the parole hearing with that in mind. And it's interesting. And again, now assuming that the attorney had nothing to do with this because he's stuck in the catch-22 of filing the habeas corpus. So now he needs to show up with saying, I lied or I'm innocent. So you have to show up with innocent. But then it's like, I can't really understand. The attorney sitting there and he keeps, have you ever been on the phone with someone? I'm sure you have. This is the most frustrating thing. You're on the phone with somebody and you're someone next to you and they don't hear but they keep whispering in your ear what to say. And it never helps. You don't need someone whispering in your ear what to say while you're having a conversation with someone. It never helps. And she kept whispering in his ear. And I was like, how is he going? He's like, and it's like, it's not, it's just not helpful. I don't think it doesn't look good either. And we see that happen a lot. And she's also like writing notes on her laptop to him. And it's like, I don't think he has the ability to like read that, digest it, and like bounce it back. It's just, it just felt like a very unprepared hearing. Again, you're going in there and you're saying, I'm going to go and get this job in a boat. My girlfriend, who I've known for 4 months, is going to drive me every day to and from my halfway house to this job. Then I'm going to get a job with my brother-in-law, although he's not married. I don't know who his brother-in-law is, like at working at these trucks, driving, even though I haven't driven a car. And for the last car I drove in was the car that I stole from the guy I killed 40 years ago. And I guess 35 years ago. No, I guess what am I saying? 40, 28, 30 years ago. I'm 1990. I guess I've been exaggerating a bit. Feels like 40 years ago. 1998. So, but yeah, horrible plan. And there you go. There you have it. If you want to see more Act 23-169 hearings, there's a playlist. Check them out. I happen to be a big fan of these hearings. I love where the ADA comes up against the defense attorney, and it's the format. I do appreciate this format. So let me know if you want to see more of it in the comments section. And with that, I'll let you go.
Sir, and I'll call you that because that's the type of woman I am. You got a long ways to go. You got a long ways to go. And you're still in denial about what you did and what part you played in this. You were stopped in the car with all my son's clothes on, except for his socks, down to the underwear. You didn't care. You never showed remorse. And all through the trial and your troubles, you did not care, not one bit, whether you want to admit it or not. But that's what you got to do first. Admit your part in what you did. Admit your part in what you did.